This is Lecture 15, the Doctrine of Equivalents 2. The agenda for this lecture is to look at the all elements rule, which you'll recall from the prior lecture is one of the ways that the Supreme Court has decided to limit the scope of the Doctrine of Equivalents. And then we're going to talk about prosecution history estoppel, which is the other major limitation on the scope of the Doctrine of Equivalents and how that has evolved over the years in the case law. So let's go to the all elements rule. The all elements rule is fairly straightforward, and the idea here is that when you're accusing a product of infringing your patent claim, you need to identify in that accused product each and every element of your claim. So here we have a claim on the left, claim 1, and then we have accused infringing product on the right. And so what we've done here is essentially found the matching component for each element of the claim. The wooden cylinder is, of course, the yellow wooden cylinder of the pencil. The cylinder graphite is, of course, the lead cylinder that runs through the center. And the small cylinder eraser material, of course, is the eraser stuck on the end. And so you do a matching, right? You match up each element of the claim to something inside in the accused infringing product. That's the all elements rule. And so you'll recall from Warner-Jenkinson that one of the key holdings of Warner-Jenkinson, although it wasn't anything particularly new to the patent law, but it was a definite holding that the Supreme Court made, was that the all elements rule applies not only to literal infringement, but also to the doctrine of equivalence. Now, what does that mean? Well, that means if we are accusing now a plastic pencil, let's say that this pencil on the right here with the green is a plastic instead of wood. It has some sort of a plastic component to it. And let's say it has a different kind of eraser and maybe a different kind of lead. Maybe it's one of those newfangled rubber leads or something like that. The issue is you still have to go equivalent by element to determine infringement, right? So starting with the first element there, the wooden cylinder element, you need to point out which piece where in the accused infringing product that element exists. And then the question is your identification, whatever you've identified in the accused infringing product, is that equivalent? And then you go to the next element, right? And note, however, that although I've put equivalence for each of these elements, it might be, and it often is, the case that you'll have a mix, right? So in fact, instead of a cylinder of graphite requiring an equivalence analysis, it might be just literally there. It might be that the accused infringing product actually has graphite as its pencil lead, in which case there's no equivalence analysis. You just point out where in the accused infringing product that element, the cylinder of graphite element, exists, and you're done. And then finally the eraser is the same, and if it's equivalent or not is, again, a fact question. The key thing to understand here is that what you do is you go element by element. You don't simply tell the jury to determine whether or not the claim on the left is equivalent to the thing on the right. Instead, the patentee has to show each and every element in the claim and how it matches up. So where the all elements rule becomes particularly important is in the aftermath of footnote 8 of Warner-Jenkinson. Right? So recall, we've had a discussion about this a couple of times. Footnote 8 is pretty important because it deals with this issue where the Supreme Court was addressing the Federal Circuit's concern, and indeed the entire patent community's concern, that juries analyzing the doctrine of equivalence were difficult to review. It was very difficult to understand whether they were going to get it right, very difficult to instruct them. And so the Supreme Court responds and says, well, here's some guidance. And one of the important things that they said about halfway through is that if a theory of equivalence would entirely vitiate a particular claim element, partial or complete summary judgment should be rendered by the court, as there would be no further material issue for the jury to resolve. So what does that mean in the context of the all elements rule? What that means is that every time you're doing an all elements analysis, you have to also ask yourself whether the equivalent that's being asserted say, for example, the plastic cylinder instead of the wooden cylinder. Now, is that something that's equivalent, or does it entirely vitiate the element itself? And we'll get back to this some more, but that's sort of where the tough part is, and that's where courts have used the all elements rule in conjunction with this vitiation principle to remove the doctrine of equivalence from juries in many, many cases, and frankly in a way that seems quite consistent with what the Supreme Court was thinking they would do. So one of the cases, in fact, one of the main cases the book had you read is a SciMed case, which is, I guess if it was me, I wouldn't put this quite in this category with the all elements rule because it deals with a slightly different issue. The technology here is catheters. Again, catheters, as probably most of you know, are long, typically made of glass or polyethylene tubes that are used in the medical profession to either remove blood, introduce fluids into the body, things like that. This is the technology here in particular is double-lumen catheters, meaning that a single catheter, a single round object or oval object, holds two, and sometimes more, but here we're talking about two lumens, two compartments, essentially two tubes through which blood or other materials can flow. The advantage of that, of course, is that you can use one catheter and both remove blood and put blood back in, for example, or remove fluids and put in feeding material, something like that. So you can do two things at once. So dual lumen catheters are important. And the important thing to understand here was the court first determines that the claim encompassed what it described as coaxial lumen catheter configurations, which is what's shown in the drawing here on the left. Coaxial lumen catheter configurations have a dual, one chamber, and then another chamber that typically runs outside. It is a larger chamber that runs outside the smaller interior chamber. What it doesn't include, the court said, are dual lumen catheters where you essentially have two tubes of essentially the same size that are next to each other, right? So that instead of one encompassing the other in a coaxial fashion, you would have essentially two of these, set right next to each other and then encompassed by the full outside skin of the catheter, right? And so the court decides as a matter of claim construction primarily that this was a configuration that only covered coaxial lumen configurations, or that this claim only covered coaxial lumen configurations and not dual lumen configurations. Now, that does not mean, of course, as we now know, that the dual lumen catheters that the accused infringing product had were necessarily going to escape infringement. The question was still, would the dual lumen configuration in this context, that element of the claim, nonetheless be equivalent to a coaxial lumen? And the patentee argues, of course, that there is a substantially the same function, substantially the same way, and to reach substantially the same result. Substantially the same function. Why? Well, it's because you've got essentially the same thing. Two simultaneous passages, fluid-based passages that work at the same time within the same catheter skin. In the same way, they do it the same way. It's two tubes encompassed in one larger tube. Same thing, right? Same result. Again, same result. They both do the same thing. You can introduce material and remove material same time using one catheter. So the patentee argues this clearly fits on the doctrine of equivalence and is certainly an issue that can go to the jury with respect to the facts. The court disagrees, however, and what they say is each of the SciMed patents specifically recognized and disclaimed the dual lumen structure, making clear that the patentee regarded the dual lumen configuration as significantly inferior to the coaxial lumen configuration used in the invention. Where such an explicit disclaimer is present, the principles of those cases apply, and the patentee cannot be allowed to recapture excluded subject matter under the doctrine of equivalence without undermining the notice function of the patent. All right, what does this mean? What this means is the court, as a matter of law, has decided that the patentee cannot, that SciMed cannot ask a jury to determine whether or not coaxial lumen configurations as claimed is equivalent to, whether or not the dual lumen configurations in the accused infringing product is equivalent to the coaxial lumen configuration as claimed, because the patentee had disclaimed those dual lumen configurations during in the specification of their patent. This is related to, of course, to the all elements rule, because that means that this element of the lumen configuration is no longer available for the doctrine of equivalence, and since it's not literally present, since it is a dual lumen configuration, not a coaxial lumen configuration, then there can be no infringement. So it relates to the all elements rule. It is actually an application of a more specific principle, which is the principle of disclaimer, whereby there's a rule that the courts have used, and it's essentially another type of legal limitation on the doctrine of equivalence, where the courts say that if you specifically disclaim particular kinds of subject matter, you cannot later seek via the doctrine of equivalence to capture that subject matter under equivalence. The reasons for this are relatively straightforward, which is we want to enhance the notice function of the patent. And if you say in your patent to the public things like, I don't want the dual lumen configuration, that's not part of my invention, then the public has a right to rely on those statements. And so therefore, if you make statements like that, if you do things like that that indicate that you do not encompass at all a particular kind of embodiment, you cannot later claim that that embodiment was equivalent to what you did claim. Now, of course, the devil here is in the details, because the question always comes up, what is a disclaimer, right? How much do you have to say in terms of disclaiming subject matter? Because as you can imagine, strategic patent drafters are very rarely going to say things in their patent specification or in the prosecution history like, I disclaim dual lumen configurations. They just don't say that, right? What they typically do is things like saying, well, my configuration is better than the dual lumen configuration. Now, is saying that your configuration is better a disclaimer, or is that merely touting a particular kind of embodiment of your invention that you think is better, but not necessarily limiting yourself to that particular kind of embodiment? And that is the difficult part, and where a lot of issues arise. But important here is to understand that that question, whether there's a disclaimer or not, is a question of law for the judge. The jury never sees this, right? So this has essentially converted a lot of the disputes about prosecution history estoppel from something that would go to a jury using expert witnesses and live testimony and things like that, to really a legal question that the judge will decide. Now, there still might be live testimony, there still might be expert witnesses, but this is something now for the judge to decide whether or not the patentee has disclaimed particular configurations during their prosecution history or in the specification. Because if they do disclaim, then there is no jury question, there can be no equivalence analysis, and if it doesn't literally infringe on that element, then the case is done, no infringement. So a case that the court, or that's in the book, it's cited in the book a couple times, discussed briefly, but I think deserves a little more treatment, that really gets at this all elements rule, is Dolly versus Spalding. You'll note it's before Warner-Jenkinson. That's because the Federal Circuit was using the all elements rule well before Warner-Jenkinson. The issue here was whether or not the device on the left was equivalent to the device on the right. And the key claim element here was whether there was a stable rigid frame claim element, right? A stable rigid frame, which in the patent was described as a series of rods connected together along the bottom. You can sort of see that, and the seat has a separate configuration. In the accused infringing product, the entire seat was molded as one piece, right? So instead of pieces being bolted together to be stable and rigid, the entire thing was stable and rigid because it was manufactured in a fashion that allowed it to do that. And so the question is that equivalent? Is there a stable, rigid frame? And the court decides that as a matter of law, there's not a stable, rigid frame because there's vitiation. Because what the single-piece molded frame does is so different from the multi-piece bolted together frame in the claimed invention, or the claimed patent, that no doctrine of equivalence as a matter of law is available. So again, doesn't get to the jury. This is a question of law, and because there was vitiation found, because it was found to have violated the all elements rule, the court said there was no question to go to the jury. So again, just an example, Dolly is an example. It's a bit of a controversial case, by the way, but it is an example of the power of this all elements rule, especially when you think about it in the context of footnote 8, which says to courts, you know, if this vitiation theory applies, there is no jury question. There is no question of doctrine of equivalence if whatever theory of equivalence is advanced has a vitiation approach. There's a few other important cases to consider. Judge Rader, who's now the chief judge of the court, has been particularly active over the years in the all elements rule analysis. Weiner had a claim that required data in columns, which was interpreted to require data on the chip to be stored in columns. The accused device stored data in columns, no question about that, but did that on an external data register. So that was found to be a vitiation of the columns element. Now note that the whole case here is really determined on claim construction, because once there was a decision made that the data that was in columns had to be on the chip, stored on the chip, then that meant that even though there was data stored in columns off the chip, that the court thought it would vitiate that claim element, and therefore no doctrine of equivalence available as a matter of law. So again, the interplay between claim construction and this vitiation theory is critically important, and indeed can often mean that there is no doctrine of equivalence available to the patentee at all. Sage Products is another case, which is the claim language required an elongated slot at the top of the container body. The accused device had something of a slot, but it was within the body. There wasn't sort of a separate top piece of the body. This was a disposal device for needles, I believe. And so it was within the body, near the top, but didn't have a separate top piece like the claim had anticipated. So the issue again is the same as Weiner and Dolly, which is Judge Rader wrote an opinion that said, well, the right construction of the claim requires the slot to be at the top of the container body. Here, you might say there's an equivalent slot, but where that slot is located, there is no top. There just is no top to the container body of the accused infringing device. It was a much more curved piece. The patentee, of course, argues that that's equivalent, right? That sort of a curving one piece that doesn't flip open is equivalent to something that's more straight-edged and does flip open. But Judge Rader thought that was incorrect as a matter of law, and that was simply could not possibly be equivalent, and therefore would vitiate that claim element. No equivalence, no infringement. So the big question with these cases, and indeed with the vitiation theory and the all elements rule generally, is where do you draw this line, right? Because taken to sort of extremes, it's the all elements rule and this theory of vitiation can essentially mean that there's no doctrine of equivalence at all, right? I mean, going back to our example about the wooden pencil versus the plastic pencil shaft, if we decide that anything that's non-wood, that any non-wood equivalence theory vitiates the element of a wooden cylinder, then that means there is no possibility of equivalence infringement, at least as to that element. So that doesn't seem, at least to me, like what the Supreme Court was thinking. On the other hand, it's hard to know where to draw that line, right? So is it vitiation for plastic cylinders? Probably not, at least not in my view, but you could imagine cases where the theory of equivalence was so different, right, that it simply, you could not make that argument. You could not make an equivalence argument. And it's hard to sort of understand where that might play out. But I have an example for you that as sort of a thought experiment, right? So we have a fastening system. This is our claim, a 2-inch long bolt, a corresponding nut with 5 sides, wherein the nut includes an insert of plastic material. So this is, a lock nut or an aircraft nut that has a plastic material that keeps the nut intact when there's vibration. So consider the equivalence, or not, of device A. Everything's the same, except the bolt is 2.5 inches long. All right, so let's go element by element. Does it have a corresponding nut with 5 sides? Yes. Does it have an insert of plastic material? Yes. Is it a fastening system? Yes. Is it a bolt? Yes. The bolt, however, is not 2 inches long. All right, so now the question is 2.5 inches equivalent to 2 inches? All right, and so this is where we get into this question again of whether or not this is something that you send to the jury and say, do 2.5 inches bolts operate in the same function, way, and result? And if so, then it's equivalent. If not, it's not equivalent. Or instead, is the theory that the patentee is putting forward here, this theory of equivalence, vitiating the claim element entirely, and therefore inappropriate for analysis under the Doctrine of Equivalents? I think that's an interesting question, and frankly, I don't think the courts have answered this very well. So look at device B. Same system, except the insert is cork, right? So does that vitiate? Again, everything's the same, right? Not a this is, again, a 2-inch accused infringing, so we don't have that issue. But instead of the insert of plastic material, we have an insert of cork material. So is that equivalent? So I think that the way the courts would play this out is that the 2.5 inches bolt would vitiate, and the cork insert would be a jury question. And here's why I think so. Numbers are extremely difficult under the Doctrine of Equivalence. We discussed this a little bit in class before, but numbers are very, very difficult to deal with because of this vitiation theory. And the argument is that the 2-inch long bolt element is extremely specific, right? They claimed that they wanted coverage of 2-inch long bolts. 2.5 inches is simply not at all the same as 2 inches, right? It is not a direct swap. You can't just swap in 2.5 inches for 2 inches, and the fact that the patentee claims so specifically is going to curtail the amount of the Doctrine of Equivalence that they get. And so my guess is that most of the time that would be determined, that 2.5 inch bolt, to be a vitiation. No jury question, no infringement, no equivalence, no infringement. I think, on the other hand, that plastic versus cork in this context of an insert used to maintain fastening of a nut is almost certainly going to be a jury question. I don't know whether it's equivalent or not. That's a jury question. You'd get your experts in to talk about function, way, and result of the plastic and the cork, but it's at least a jury question. And so I think it's interesting to think about how different kinds of claim elements can play out quite differently with respect to the all elements rule and the vitiation theory. And so I wanted to flag that for you. And here's one other thing I wanted to note for you, which is We have two claims here. Claim 1 on the left, a fastening system comprising a 2-inch long bolt, corresponding nut with 5 angled sides. Claim 1 on the right, a fastening system comprising a bolt, said bolt being 2 inches long, a nut, said nut having 5 angled sides. So, which one is a broader claim? Any ideas? Well, if you thought to yourself, they're the same, you would be correct. They have the same elements. They're just lined up a little differently. But here's the trick. They may not, in fact, have the same scope. Why? Because if you're talking about the Doctrine of Equivalents analyzed under an all-elements rule, where there's the risk of any theory of equivalence that you put forward being determined to be a vitiation type theory, then the more elements you have in your claim, the more likely it is that the accused infringer is going to be able to win on vitiation. Now, we would hope, obviously, that this is essentially a semantic difference, that this wouldn't actually matter. But it probably does matter. I mean, this is a very simple, stylized example, so that this doesn't come up just like this. But the way that you organize your claim, given the importance that is now placed upon specific claim elements, right? The way you organize your claim, the way you describe things like numbers, whether you put the words approximately in, whether you put numbers in your claim at all, is going to matter a lot with respect to the amount of the Doctrine of Equivalence scope that you can potentially get. Ideally, this would not be the case, but you can see how it plays out given the way that the doctrine has worked. Next, let's move on to prosecution history estoppel. I think the easiest way to sort of dive into the analysis of prosecution history estoppel is through an illustration. So let's consider the following. Patent 123 discloses a lighting system using colored bulbs. A blue color is given as the example and the specification. The prior art contains a lot of very similar systems, so it's a crowded art field, including those using red colored bulbs. And let's say, for example, that the red bulbs, among others, were presented to the examiner, and there was a discussion during patent prosecution about the claim scope. So in scenario 1, what happens is the original claim that was filed was a lighting system comprising a colored bulb. There were other elements too, but let's just focus on one element here. So it included a color bulb. Because of the prior art that was asserted against it, the examiner, or the patentee, amended their claim to say a lighting system comprising a blue light bulb. They narrowed their claim. They essentially narrowed it from colored to blue. Scenario 2 is slightly different. Same claim, same invention, but the claim as filed is different. Right? The original filed claim is a blue light bulb, a lighting system comprising a blue light bulb. Because that claim was narrower from the outset, and there were no amendments. The patent examiner did not require any amendments, and the claim was issued as originally filed. So you will note that at the end of the day, both scenario 1 and scenario 2 have the same claims, right? So the scope should be the same. Well, is it? So which scenario, scenario 1 or scenario 2, covers lighting systems with blue bulbs? Well, that's easy. They both do, right? That's just basic literal infringement, right? Blue bulbs are claimed. It clearly covers with blue bulbs. How about lighting systems with red bulbs? Okay, well, it obviously doesn't encompass literal infringement, right? So then the question is whether or not there is a infringement under the Doctrine of Equivalents, right? And how do you deal with that? Well, you say, is the element blue light bulb equivalent, is the red light bulb equivalent to the blue light bulb, right? Now, as we're going to find out in our next class, it's extremely unlikely under the law that that either one of these scenarios would get coverage over red light bulbs, all right? But for different reasons. The reason that scenario 1 would not get coverage over red bulbs is because, as you'll remember from the hypo, the red-colored bulbs were asserted as prior art. The red-colored bulb systems were asserted prior art, and the patentee surrendered that coverage in going from a colored bulb claim to a blue light bulb claim element. And because that was asserted against them and they surrendered it, they cannot recapture it through the Doctrine of Equivalents. Now, as we'll find out next week, and I'll give you a quick preview, or not next week, next class, I'll give you a quick preview on this. The scenario 2, it probably wouldn't work either because you can't use the Doctrine of Equivalents to encompass the prior art, and since lighting systems with red bulbs are in the prior art, you could not get that coverage under the Doctrine of Equivalents regardless, right? But where the rubber meets the road here with respect to prosecution history estoppel is on the green bulbs, right? So the green bulbs were not in the prior art, right? They were not asserted against this patentee when he was prosecuting or she was prosecuting the patent. And so the question is there infringement, or at least possible infringement, on the Doctrine of Equivalents, right? And here, scenario 1 and scenario 2 end up in very different places, because in scenario 1, the argument is that there is prosecution history estoppel that attaches to that amendment. And because that scenario 1 gave up colors other than blue, perhaps there's no Doctrine of Equivalents available to cover green. On the other hand, perhaps there still is, because what was asserted against the patentee in scenario 1 was merely systems with red bulbs. So should we interpret their surrender, right, their claim amendment that surrendered claim scope, to be one where they gave up everything except for blue, or one that they merely gave up red? Or should it be something in between? Scenario 2 is an entirely different creature here, and that is you will just send that to the jury. There's no prosecution history estoppel on scenario 2. They claimed narrowly to begin with. They didn't amend their claim. There's no prosecution history estoppel. There's no question about whether the Doctrine of Equivalence is available. It is. Now, it's a fact question as to about whether green bulbs are equivalent to blue bulbs, and you would send that to the jury, and they would have to decide that on a function, way, and result basis. And I don't know how that would work out, but at least that's available. But on the scenario 1, it's a very tricky question, and it really depends on the scope of prosecution history estoppel. So the Festo case is sort of the culmination of the debate that I've set up in scenario 1, right? So the Federal Circuit, post-Warner-Jenkinson, started using prosecution history estoppel as one of these ways of limiting patent Doctrine of Equivalence in a significant fashion. And in doing so, it determined in a Festo case, in the earlier, the Federal Circuit version of Festo, that the right way, after a lot of debate internally with the court, that the right way to understand the scope of the surrender, right, here, when I amended my claim from colored bulb to blue light bulb, how much scope coverage did I give up? Did I give up only the red bulbs that were in the prior art, or did I also give up everything that wasn't blue? And the Federal Circuit decided in its Festo case that the patentee would be deemed to have given up everything other than blue. The theory here is that once you have given your attention to this particular element, you now must take the good with the bad and decide that this is going to be the scope of that element. And you don't get to, once you have amended a claim element, once you have focused your energy and attention on a particular set of language, that language should be able to be relied upon by the public for what your scope of invention actually is. And because of that, this is known as sort of the total surrender approach. The other approach, the approach that would allow only losing the red light bulbs, is essentially a no surrender approach, because as I said a few minutes ago, in no event can you use the Doctrine of Equivalents to cover the prior art. So it would mean that basically prosecution history estoppel didn't really matter, because in any event there wouldn't be Doctrine of Equivalents in this case. And so, that's there. What the debate was, and what some members of the Federal Circuit thought, is that there should be a flexible surrender, meaning that in every case it'd be a case-by-case analysis to determine what was actually surrendered when you amend your claim, for example, from colored bulb to blue bulb. It's more than red, right? You've given up more than just the prior art, but you haven't given up everything. So there is still Doctrine of Equivalents available, right? And so that's the issue that gets taken up by the Supreme Court in Festo, right? And the Festo case tries to deal with what is going on with respect to the interaction between the Doctrine of Equivalents and prosecution history estoppel, right? And they say some interesting things, right? They say the language in the patent claims may not capture every nuance of the invention or describe with complete precision the range of its novelty. If patents were always interpreted by their literal terms, their value would be greatly diminished. Unimportant and insubstantial substitutes for certain elements could defeat the patent, and its value to inventors would be destroyed by simple acts of copying. For this reason, the clearest rule of patent interpretation, literalism, may conserve judicial resources, but is not necessarily the most efficient rule. The scope of a patent is not limited to its literal terms, but instead embraces all equivalents to the claims described. This is basically a defense, citing Winans, of course, of the Doctrine of Equivalents, explaining what the court's theory of the Doctrine of Equivalents is, right? And again, it's focused on the nuance, the difficulty of language. So, unfortunately, the nature of language makes it impossible to capture the essence of a thing in a patent application. The inventor who chooses to patent an invention and disclose to the public rather than exploit it in secret bears the risk that others will devote their efforts toward exploiting the limits of the patent's language. That's true. And again, as we've talked before, I think this is probably the best argument for the Doctrine of Equivalents, is that it's almost impossible to capture the essence of a thing in the words that you're required to provide in a patent application. By amending the application, the inventor is deemed to concede that the patent does not extend as far as the original claim. It does not follow, however, that the amended claims become so perfect in its description that no one could devise an equivalent. After amendment, as before, language remains an imperfect fit for invention. The narrowing amendment may demonstrate what the claim is not, but it may still fail to capture precisely what the claim is, right? So this is a rejection of the Federal Circuit's total surrender doctrine, right? Instead, what the Supreme Court does is they move back towards a more flexible surrender doctrine, although it's a flexible surrender doctrine that only works when a few circumstances that you can read in the case, which are frankly complicated and probably not worth going through at this point, but they're using essentially a version of a more flexible system. Now, it is not as flexible, it is more rigid than what the Federal Circuit was doing before it started getting serious about prosecution history estoppel. So it falls somewhere in between, and it's sort of a middle ground approach among all of the different approaches to prosecution history estoppel. So the scope of your surrender when you amend your claim is not total, but it may well be total unless you fit into one of the three categories that the Federal Circuit lays out with respect to those that particular claim amendment. And I leave it to you to look in to sort of read through those and figure out what the court really means. I do note that there's been much debate at the Federal Circuit ever since Festo, trying to figure out exactly what the scope of those mean, and I'm not sure we do particularly well at this point. But what I want to leave you with here is this question. So both the Federal Circuit and the Supreme Court describes prosecution history estoppel really as fundamentally part of the doctrine of equivalence, and that means sort of this tension that exists between the doctrine of equivalence and public notice. And the question I want to ask you is whether you think that's really the case. It might be that prosecution history estoppel is about something quite different. And understanding this, I think, requires going back to our example, right? Which of these two scenarios is better from a public policy perspective? I would argue that scenario 2 is the better public policy. Why? Well, because the patentee in scenario 2 has claimed reasonably, right? They did either prior art research, or they just narrowly focused their claims on the actual invention that they wanted to cover, rather than the patentee in scenario number 1, which attempted initially to claim significantly more than was available to them, given the prior art. Scenario number 1 has a lot more costs, right? It requires the patent office to exercise a lot more work, find more prior art because it's a broader claim, issue more rejections because it's a broader claim that interferes with more prior art, has potential disclosure and other problems. It might be that the patent office doesn't get it right and allows a claim like the original Claim 1, and in which case it imposes significant costs on the public to have that claim out there, which may well be invalid, but can be difficult to invalidate in the litigation context. So my argument is that what we want patentees to do is more along the lines of scenario 2. We want them to have done the research, to have figured out what they can claim, what they can't claim, and to do it at the outset, and not draft claims that are so broad and see whatever they can get from the patent office. So if you think that's true, then maybe prosecution history estoppel is about that. It's about providing incentives for patent prosecution. It's about providing incentives for drafting claims reasonably, about providing incentives to not overclaim in your initial claim. Because if you do so, if you draft reasonably, then the reward that you get is some scope of doctrine of equivalence for those elements. It may not be much scope. Again, there's still a lot of other limitations to the doctrine of equivalence that can apply in any given case, so I'm not saying that this, dramatically increases the value of your patent, but it certainly makes a difference because it means that it's available to you to have the doctrine of equivalence for these elements, versus if we took prosecution history estoppel seriously, having essentially no or almost no equivalence available to you for those amended elements. So the question I want to leave you with is that maybe that's the better way to think about what we're trying to do with prosecution history estoppel, and that we should understand that prosecution history estoppel, although it applies with respect to the doctrine of equivalence, and it certainly has something to do with claim scope, that it really is an attempt to generate incentives for patentees to be straight with the patent office at the outset, rather than fighting and drafting too broadly. So I'm going to leave you with that, and that's Lecture 15, the Doctrine of Equivalence 2, and I will see you next time.